When you're lost in a world of legal war, and you don't know which way to go, there's a hero waiting with expertise to lend. The Utah employment lawyer, HR's best friend.
Welcome back to HR's Best Friend, our podcast for HR professionals and business leaders who want to make sure they stay compliant, don't get in trouble, and keep their employees happy. D. Scott Crook is the Utah employment lawyer. He's consistently listed in Rocky Mountain Super Lawyers and Best Lawyers in America. He is the managing partner of Crook Legal Group. Scott is only licensed to practice law in Utah and Idaho. He is not giving specific legal advice in this episode. This shouldn't be construed as legal advice for your problem. If you need specific legal advice, please go to an attorney. Scott is an attorney, and I will leave it at that. So, thank you for coming. Before I get into this episode specifically, just wanted to mention that we are having an event on April 19th from 9:30 to noon. My dad and Carolyn Howe, one of our employment attorneys, are going to be discussing the legislative session that just closed in the Utah legislature and talk about the new laws that were passed that may impact employers in the state. So we're going to be serving brunch. There will be a live streaming option available. We'll be doing that over LinkedIn Live and YouTube Live. And but you are welcome to come in person at the Walker Center. That's where it's going to be. If you're interested in attending, please contact us. You can find us on the contact page of our website, crooklegal.com. If you didn't already receive an email inviting you, please let me know if you'd like to be there. Come eat brunch with us and learn about these things that are these laws that are going to impact you. And or if you can't come in person, then we'll get you the link that you need in order to attend. So now on to this episode. We are going to go over an episode of The Office called Branch Wars, where Stanley is recruited to another branch of Dunder Mifflin, and Michael and Dwight crusade to take revenge on this other branch. So we'll be breaking down any employment law issues in that episode. We're also going to discuss a current event. A prosecutor in Bakersfield, California, filing a lawsuit about the dress code. So if you're interested in learning more about dress code things, how that works in Utah, this is a good episode for you. And then we have a couple of anonymous questions from Facebook and Reddit. So anyway, we'll jump into the episode. Thank you so much for tuning in. And again, if you're interested in coming and eating brunch with us and learning about the new laws and how they're going to impact you, please reach out to us by going to our contact page on the website and just fill out our contact form or call us and we'll get you more information. Welcome back to HR's Best Friend. Again, Dad, have you watched any March Madness so far?
Yeah, I like March Madness usually, but I've been so busy I haven't watched one game this time.
Really?
Not even a minute.
I watched Purdue really take it to Utah State for the first half.
Yeah, I heard that was pretty bad.
Yeah, Utah, they were, for the first 10 minutes, it was competitive. But then every single one of Utah State's big men got in foul trouble. And it got really ugly really fast. So
that's too bad.
I did watch that. I didn't see BYU lose. But they always lose.
Oh, in the NCAA tournament, when they get there lately, they have not won.
Yeah. It's too bad. I miss Jimmer.
Who doesn't miss Jimmer? Apparently the Sacramento Kings.
The Phoenix Suns and the Milwaukee Bucks, the team he was drafted to and then immediately traded to the Kings. Anyway.
Yes.
Yes. he's had a very successful pro career, just not in the NBA. So
Yeah,
good for
the
him.
Shanghai, was it Sharks?
Shanghai Sharks. Yeah.
Yeah.
His
Yeah.
nickname's the Lonely Master, which is a really cool nickname.
Yes.
So good for him. Anyway, moving on to what we do. We're going to talk about some employment law things. We're going to start by going through a sitcom episode and looking for the interesting tidbits in there. And this week we're going to look at The Office, and we're going to do the Branch Wars episode. So let me give you a quick plot summary. So Stanley, who is a salesperson at the Dunder Mifflin branch, is offered a job by the Utica branch. And the Utica branch is managed by Karen, who is Jim's ex-girlfriend. To pursue revenge, the manager of the Scranton branch, Michael, decides to pull a prank on the Utica branch. And then the other plot point to pay attention to is that there is an exclusive club in the Dunder Mifflin branch called the Finer Things Club. It is a closed club where they discuss literature and eat finger foods. And the most obnoxious person in the office wants to join that club. So there are our plot points. So here's a scenario from that episode. So Michael and Dwight tell Jim that they are going on a sales call and need Jim's help. Jim agrees to go. As they drive, they pass the exit they were supposed to take for the supposed sales call, and Michael and Dwight tell Jim they're actually going to Utica. So here's the first point. Jim says he's not going because he doesn't want to make Karen, his ex-girlfriend, mad. He pulls out his phone, presumably to call a cab, and Dwight throws the phone out the window. Is there anything there that a employment lawyer would want to discuss?
There's so many things there that an employment lawyer would want to discuss, but the problem is I don't know that.
It's funny because when I go through these things, I'm like, is there really anything there to talk about? And it's just funny that your reaction is there's so much to talk about. So.
Well, from an employer's perspective, this is more of an individual problem. Like it's, Michael's kidnapping somebody and
Right.
Dwight, assisting in that kidnapping. I think there's certainly individual claims, whether the employer could be vicariously liable. In other words, whether they could be liable for the actions of the individuals is questionable. In this case, what did they remind me again? What did they tell Jim they were doing?
They told Jim that they were going on a sales call because Staples had been fired by some client, and so they were going to go try and win that business.
Okay,
so
yeah. So
they lured Jim into the car on that pretense.
Yeah, and since Michael is Jim's boss, and since that would ordinarily be something that you would expect, that would be ordinarily in Jim's scope of employment, you could have an argument that Dunder Mifflin itself could be liable, not just Michael. Generally, employers aren't liable for the intentional torts of their employees that are outside of the scope of their employment, and tort is just a personal injury. So, like, for instance, like if Michael had punched Jim, or of course, Michael got punched by, was it Dwight in that one episode in the stomach?
Yeah, there was the yes, where Michael tells Dwight to hit him. Yes.
Yeah. But if Michael had, so in the scenario, if Michael had punched him, that would be considered battery, and normally an employer is not liable for that kind of action of its employees unless the employer can expect that an employee might be in that situation. So a bouncer, for instance, you might expect a bouncer to punch somebody, so you might get liability there. But in any event, there's probably not a whole lot that they can come back on Dunder Mifflin itself for.
Okay. All right, well, let's move on to this next part, which is, okay, so Dwight throws the phone out the window. They pull over because Jim says that, he's taken all the pictures of his brother's new baby with that phone. So they pull over to find it. And while they're pulled over, it is revealed that they have brought uniforms to impersonate warehouse workers, silly string, and gasoline and chunks of rubber. And Dwight has filled bottles. He's assembled Molotov cocktails in the back of the trunk. So is there anything additional there? The fact that they're driving around with this stuff, that they're intending to do these things to this other branch?
Yeah, I don't I don't see that there would be a whole lot of individual liability. It's really a bad idea.
Yes.
As you can tell. But I don't know that Dunder Mifflin would be on the hook for that again.
Okay. All right. Second scenario. So Toby, Oscar, and Pam are having a Finers Thing Club meeting. They are discussing a novel and eating snacks that Pam has made. Andy, the most obnoxious person in the office, attempts to fit himself into the conversation by sitting at the table, and they tell him he can't be part of the club. So I was just curious if Dunder Mifflin could get in trouble for having employees having an exclusive club at work that some people can't join.
Well, not really. You could. There could be scenarios where it could be, but if this were on their off time, which this is their lunch time or their off hours, they're using the company facilities to have the meeting. For the most part, you're not going to have problems, but you could in some scenarios have problems. Like, for instance, if it were a meeting of the Ku Klux Klan, for instance, and it made the employer could have liability for the off-duty conduct if it's even if it's at the office and they're being racist and they obviously feel uncomfortable. Obviously, that could raise some issues. In this case, where Andy is only excluded because he's obnoxious and because he probably won't read the novels that they were discussing. I can't remember what book they were discussing, but
I looked it up. It was I think it was A Room with a View.
Oh, well, yeah, because what they're doing is just these three people like the same things, and so they're doing, they're eating together. That there's really no potential liability there unless the person's being excluded because of some protected class and or what they're doing is discriminatory and there's a complaint made.
Okay. Very good. Okay, next. So back to the Jim, Dwight, Michael storyline. Michael and Dwight try to steal the industrial copier from the Utica branch and end up dropping it down the stairs and hurting themselves. Anything there to discuss?
Well, sure. There's obviously, aside from the trouble that Michael and Dwight are going to be in for breaking equipment, there's the fact that they hurt themselves, even if they're doing something
in the show. I don't think there were actually any consequences besides Karen being mad at them, but in real life that would probably not be the case.
Oh yeah, they'd probably be both of them fired, but but the fact is that there could be some workers' compensation issues that arose even when they're fooling around and they're injured. That's something you'd have to report as a potential workers' compensation claim because it happened at work. Using work equipment, even though they were horsing around, they might not have coverage in that circumstance, but you'd still need to report it as an employer.
Okay. Okay, in the last scenario, which you've basically already answered, at the end of the episode, Pam invites Jim to the Finer Things Club. But you've already said that's really not an issue. So
No, it's not an issue. I will have to say, I do want to say this, though. You know, I've been reading the biographies of the presidents in order.
yes.
And it's remarkable to me. I just got done reading Chester Arthur's biography. He was number 21. And
Yes, he was
before
known
him
to his friends, Chesty.
no, he was actually known as Chet by his
Oh,
friends.
okay.
And James Garfield, you know, was the president who was assassinated that made Chester Arthur the president. But what's remarkable to me is, of course, they were stalwarts. That's the group they belonged to in the Republican Party, which was led by a great orator and somebody who was a leader of the stalwarts named Roscoe Conkling, who was very famous at the time. He was from Utica, just so you know. I'm just bringing it all around.
Thanks for that. Did James Garfield like lasagna?
It didn't say whether he did. I don't think he would, though. He didn't seem to have the personality that would like lasagna.
Did he share any personality traits with Garfield the cat? Is really what I'm asking.
Well, other than he was apparently a little bit chubby in his later years, maybe.
Okay.
And he did
All right.
have a lot of facial hair. So
Okay. Good. All right, moving on. So, okay, I've got a current event here. I find these current events by Googling lawsuit and then filling in different things in front of that, like discrimination and harassment. So here we go. So this is in Bakersfield, California, but again, for our purposes, we just interpret everything through Utah lens. Pretend it was Utah.
well, you'll be interested to know that Bakersfield, California was very close to where I lived as a kid when my dad was stationed at Edwards Air Force Base. And I'm very familiar with Kern County because that's the county I was in. And I've been to Bakersfield dozens of times when I was younger. But anyway.
Well, good. I'm glad that this has turned into Scott's story hour. So here's what happened. So former Kern County prosecutor. Okay, I don't know. I don't want to try and pronounce that. The former Kern County prosecutor, Nishi Dial. I'm probably butchered that, but we'll just call her Nishi. She says supervisors at the district attorney's office objected to her social media posts, reprimanded her for wearing traditional religious tattoos, and told her not to wear skirts to work, even during Bakersfield's scorching summers, unless she also wore pantyhose. The last one posed a particular problem for her, according to a federal lawsuit set for a scheduling conference next month. She has fibromyalgia, a painful disorder that limits her mobility and prevents her from wearing stockings or certain footwear. After multiple reprimands, she was demoted. According to the suit, she went from hearing felony cases in Bakersfield to being assigned misdemeanor cases in Delano. You lived close to Bakersfield. Is Delano a big step down from Bakersfield?
Honestly, I don't remember Delano. I would guess that it is, but
just based on the way they framed that, it sounds like that's the pit of the earth. Okay. 4 months later, she resigned, exhausted by the ongoing discrimination, harassment, and retaliation. Kristen Davis, public affairs officer for Kern County Superior Court, said there is no specific local rule of court regarding dress code. Attorneys are expected to dress professionally, she said. However, they certainly do not require a woman to wear a skirt or pantyhose. The district attorney's office has its own dress code policy and has had one in place for at least 30 years. Among the requirements for women are that pantyhose will be worn with dresses, skirt suits, and dress suits. Some type of sock or stocking must be worn with pantsuits, according to the most recent version of the policy issued in October 2022. Regarding footwear, business-style shoes should have a heel and closed toe or peep toe. The policy says flats with a heel are acceptable. Shoes should be clean and shined. Tattoos must be covered. So, break it down.
Yeah, this is interesting. There's all kinds of issues, but this is an issue that arises a lot with the the movement of law, the legal landscape over the past few years have made dress codes particularly problematic. And that is because now the Supreme Court has, within the last few years, recognized that Title VII protects against sexual orientation discrimination and also gender identity. And so what that means is a lot of dress codes that have been in place for a long time are now probably violations of the statute. They probably were violations before that, but simply because the EEOC will interpret them pretty strictly. And so if you have a dress code essentially that has like, here are the dress code requirements for women, and here are the dress code requirements for men, you're almost assured to be in violation of Title VII, according to how the EEOC interprets it. So the best way to deal with those sorts of things is to, of course, have an employment attorney look at them. But if you have sex-specific requirements and that you can't justify other than because there's a stereotype that's associated with that sex or because of gender roles that you think are applicable to that sex, there's a problem. And so in this particular case, the fact that I'm actually quite surprised that it's, well, I don't know, I should say if I'm surprised, but the fact that this is an attorney's office that has this dress code that says women must wear, if they wear skirts, must wear some sort of stocking, that signals there's a problem and they're probably going to have some issues. Now, it's not, that's not to say employers can't have dress codes and they can't have, it's certainly okay in Utah to have a dress code that says you have to have no visible tattoos, for instance. However, with every dress code, it's still subject to the other requirements of Title VII, which include reasonable accommodation for religion. So, for instance, if your dress code required men to have short hair, but for religious reasons, some men might need to have long hair, you would have to accommodate that unless, it's for safety reason or something. Or for religious reasons, for instance, if you said no one could wear a hat, or no one, everybody's head had to be uncovered, that might, again, be a violation if somebody had a religious problem. So in this case where they said she had to cover up tattoos, however, if those had religious significance and she was required to keep them uncovered, if she asked for an accommodation, they would probably have had to have accommodated her. And same with the pantyhose, even if that were an enforceable policy, if she could say that because of her fibromyalgia and she asked for an accommodation, then the ADA would require that there be an accommodation.
Okay. So it sounds like that case could go well for the plaintiff.
It could, but it's all fact dependent. And if she never asked for the accommodation, then she doesn't have, she could lose. And also if her description of the events aren't quite as bad as that she described, then of course she could not prevail.
Okay. All right. Now it's time for anonymous questions. I have my favorite anonymous question ever so far here.
Okay.
It says, I have an employee that is a therapist of adults and children who does pole dancing classes. She posts videos of these classes on her personal social media. A parent of a child she is counseling saw them and made a complaint and feels she shouldn't be counseling children. She posts under a different name. How would you handle a complaint like this?
Well, so in Utah, we've talked about this before, there is a specific provision under the Utah anti-discrimination statute which says that employers cannot discriminate against a person for their religious or moral views expressed on social media outside of work unless there's a business purpose for it. This isn't actually that unusual. I'm not talking about the pole dancing part, but I'm talking about the fact that people will get complaints by customers um, or clients because they've seen something on social media and they don't think people should employ those kinds of people that did what X or Y. And honestly, most of the time, what people do outside of work, unless it, unless you can show some connection with what's happening at work, at least it can impact. Well, I guess I have to say this differently. Let me start back. And you can hire or fire a person for any reason or no reason at all in Utah, even a bad reason, as long as it doesn't. As long as there's no statute that prohibits it, it's not a violation of public policy, or there's not a contractual provision that would prevent it. So if you got an anonymous call or you got a call from a client that they were uncomfortable because somebody you employed as a pole dancer on Facebook on her off time using a different name, you could terminate that person for pole dancing on or off time showing it on Facebook. Unless there was some sort of moral, in Utah at least, if that had something to do with, an expression of a moral belief or something.
You haven't heard of the First Church of the Pole Dancers?
You say that, but there are cases where people have said that they've actually created churches that they said that they have to do particular things. I can't remember. I'll remember the case in a minute, but the fact is that you could probably let that person go. Now, the question is that smart? Is that something you ought to be doing? And that's a question you have to ask yourself as an employer. As just because somebody teaches pole dancing, I mean, it doesn't necessarily mean that they're unfit for being a counselor to children, whether on their off-duty time. And I don't know, it's so fact specific, it's hard to give any advice. But if that's the only reason, and whether you want to do anything or not is another question. And I would probably caution you to take any action without first trying to evaluate the situation and see if it's really a serious issue.
All right. Okay. I have one more anonymous question. It says, I do want
to say one other thing though. If you're a public employer, you may be even prevented from doing that because of the First Amendment, because they could say that's an expressive activity. I can't be terminated because of this thing that I'm doing on my off time. Anyway, there can be all kinds of reasons why that could win or not win.
Makes sense. Okay. Makes sense. All right. Next one. I have an employee, Hannah, who came to me stating she saw an interaction with 3 employees that she was concerned was related to bullying. Months ago, the project manager apparently raised her voice to the 2 other employees from another team, and she felt like it was bullying. She couldn't give me names or dates of the employees. She couldn't give me names of the employees or dates, but did give me the project manager name. I asked if there was name calling, eye rolling, etc., anything that clearly indicates bullying, and she said no. I asked if this has happened more than once, and she said no. I spoke to a few other employees on the team and vaguely asked about whether other issues were going around, and they all said Hannah was the one who was severely sensitive with her work and often got upset. Having a hard time wrapping this up due to lack of info, but trying to see if I'm missing something. What would you suggest the next steps are in this scenario? My plan was to email her and conclude the bullying claim that this did not classify as such, but honestly, I don't know if I should even divulge anything to her since she was a witness. No claims were made on our end from the 2 employees being yelled at. Thanks in advance for any advice.
So the interesting thing about this is that this is really, unless this in Utah, if someone's bullying another employee at work, there's really no actionable claim. Now, I'm not saying that's a good thing to happen, and HR still has to deal with that because you're not dealing with a legal situation. You're talking about a morale situation. So I do have to say that there is an exception in Utah. If you're a public employer, there is a statute that applies to public employers that says that really bad bullying is illegal. So it would, that's not the name of the statute. Really bad bullying is bad, but it's got to rise to the level of a serious, where a reasonable person would feel significantly bad about what was going on. Okay, so on average, most people would find what was happening was clearly out over the line. But for the most part, private employers, if you have bullies at work, that's a morale problem. It's not a legal problem. And certainly, if that bullying had anything to do with a protected classification, then you certainly have to worry about that, and you have to do something about it. So, in answering this question, I'm saying that from a legal perspective, there's really not much else you need to do. In fact, you don't need to do much at all because you're not required to, unless it was, if you're a public employer and it fell under one of those things that doesn't sound like it did. But assuming, let's say, for instance, I'm going to change the scenario a little bit and say they were being bullied because of their race. Well, at that point, you do have to conduct an investigation, even if a person didn't come forward, if someone's seen it. And you do have to do an investigation, but if no one's come forward, like no victim has come forward and said anything has happened, and no one can really recognize what occurred, you've done all that you really can do. And you can, the person who reported it, I would probably bring them into the office and say, hey, thank you for reporting that. We've done an investigation. We've taken all the necessary steps that we need to. And that's probably all I would do with that person. If later someone came in and then complained and said, hey, this happened to me, and then I would reopen the investigation, because at this point, there's just no way to know what's really gone on, and you've done what you can.
Okay, excellent. Well, thank you. Those were all of the topics we had for today. Oh, by the way, I should bring up, and I'll bring this up in the intro that I record later. We're doing a brunch event, we're going to be talking about the new legislation that has happened in Utah that could affect employers moving forward. That's going to be on April 19th, 9:30 to 12 a.m. to p.m., not p.m. to a.m. We're not insane. Wait, would it be? Yeah, a.m. to p.m., not p.m. to a.m. Yeah, but anyway, we will, there will be brunch there, but we're also going to be live streaming it. We won't be providing lunch for the brunch for the live streamers, but you've done these before, Dad.
Yes.
They're useful, they're handy. If you're an employer.
What we're going to do is, in Utah, the legislative session just finished, and most statutes don't become active until May 1st. And so we're going to have this seminar to go over those things that might affect employers that will. And so we're happy to do it. And we're principally, we're going to do it for those who have an interest. And so we would encourage you, if you want to watch and then to participate if you can. So that would be great. We'd love to be able to have you watch.
Great. Yeah, if you're interested in that, we've sent an email out to most of our clients, but if you didn't get it, or you're not one of our clients yet, just go to our website and contact us, and we'll make sure you get the info you need to be there. So thank you, everybody, and we will talk to you next time.
Thank you.